Rebecca Chen. We're going to today discuss about the travel ban, the continuation of the travel ban. We're going to discuss about if there is going to be a second lottery and if the second lottery is going to be there when and how it's going to happen for the second lottery for the H1B. We're going to discuss about next year's H1B lottery, how it's going to be, what are the things, what are the changes that are going to happen, how people need to be prepared with that. We're going to also discuss about the immigration judge that ruled that from now onwards they're not going to use the word alien, especially in the immigration courts. I really like it. I don't want to be called alien. So these are the things that we're going to discuss. Rebecca, what's going on the travel ban? I mean, when the travel ban came in the May first week, though, of course, they said they're going to review it every month. What's going on right now?
Yeah, so some bad news about the travel ban. There was some hope kind of earlier this summer that we may see an easing of the travel restrictions, especially some of the ones for Europe, the Schengen area that had been in place for a long time, over a year by this point, and hoping that those travel bans would be lifted or eased. Yesterday, the White House stated that they do not plan to lift any of the travel restrictions that are in place at this time. So that includes, of course, the one from India. We were hoping that if the European travel ban would be lifted soon, that the India travel ban would also be lifted when the health condition starts to improve. However, the White House press office has stated that they have no intention of doing that in the near future due to the rise in transmission of the Delta variant of the COVID virus. So we're expecting at this time the travel ban most likely. What do you think, Rahul? When will it be in effect?
I definitely think so. It's going to be there until the end of this year, and if not more. So I want people to be prepared. If you are traveling outside the country, especially to India, though, if you're trying to get a visa there, they most probably will not grant you a visa unless you're exempt from it, or you will be granted an exemption because of the national interest exemption. To get the national interest exemption, though, the drop box is not enough. You will have to go for the interview, and the dates are backlogged so significantly. So if you're planning to go back, please try to stay there for at least 6 to 7 months before you can come back. And that's the least minimum period that I'm speaking about. It could be even worse. For those people who are stuck in India, what can they do, Rebecca?
Yeah, so it makes a big difference whether you have a valid visa stamp in your passport or not. If you do, of course, one of the simplest ways that bypasses the consulate altogether is if you go to a third country like Sri Lanka or Mexico, stay there for 14 days before traveling into the US. It's a much different situation if you do not have a valid visa stamp. As Rahul mentioned, the Dropbox route is still there technically, but in order to get a national interest exception, it does still require an in-person interview, and so you still need to email the consulate according to the instructions on their website to submit the evidence that's listed there. It's kind of a whole questionnaire on how you think you qualify for the national interest exception. Email that to the consulate and wait to see if they will call you in for an in-person interview. Then in the in-person interview, you need to make your case again, bring in any supporting documents that support your claim for the national interest exception, and hope that is successful. That is all, of course, a very long process, and so we recommend that if you are not in India right now, if you're here in the US, definitely think very carefully before traveling if you know that you'll need to go through that process.
Rebecca, with regards to the H1B lottery, though, I mean, last year we had a second lottery. Do you think so there is going to be a second lottery? Can you explain what a second lottery is? Did it ever happen? Last year it happened. Did it ever happen before? And how if the second lottery happens, how would the people know? And when should they file their application?
Right. So The second lottery, last year was the first time we saw that happening. It's not actually a second lottery, I would say. It's a second round of selections from the lottery submissions that were already made in March of this year. So it's it's kind of a byproduct of the new electronic H-1B registration system that was put into place for the first time last year, because all the potential lottery registrants are all entered online in March. USCIS has all that data. They couldn't really do a second round of selections in the past because when they received the physical applications, if they couldn't select one in that first round of selections, the petitions got mailed back to the petitioners. So with this electronic system, they have all that information still in their portal. And so if they determine that they did not receive enough applications by June 30th to meet the 65,000 and 20,000 caps for the H-1B applications, USCIS has all that data in their system. They can just select additional individuals that were not selected the first time and invite them to submit an application. So that is what happened last year. We started, so you don't need to submit anything additional in order to be put in consideration for this second round of selection. It's basically if you were already selected in March but not selected at that time, you're already in the potential pool for a second round of selections. And the way it happened last year was that we just started getting email notifications that there was an update in the MyUSCIS portal. So the MyUSCIS portal is where you submit your lottery registration, the employers and attorneys. So this won't be in the MyUSCIS accounts of the beneficiaries, of the employees. It's in the accounts of the petitioner, the employers, or the attorney if they used an attorney to submit the registrations for them. We just got email notifications that there is an update in your MyUSCIS account. We log in and then we see that there are additional people selected, and the selection notice is uploaded there just like in the first round in March, and you're invited to submit the petition. Last year, I believe the deadline was November 16th to submit that new application.
Rebecca, with regards to the next year lottery system, they said that it's not going to be lottery system. It's going to be based on the wage level. So for example, if let's say I'm a software professional, software developer, I have a higher chance if I am in the 4 level, and most probably if I'm in the level 1, I would not have any chance. It's not going to be based on the lottery system. Can you explain what this new system is? What's going on? I mean, does it mean that when we file in March, we have to see, we have to tell the clients, hey, if you're level 1, you may not get in the lottery? Or is there anything going on the USCIS or from the lawyer's side on it?
Right, so this was a proposal by the Trump administration kind of in the last months of the administration. They put out this proposal to basically alter the way that the H-1B lottery selection was done, basically giving priority to registrations based on which tier of the wage level that they fell into. So first priority would be given to anyone who was being offered a salary in the level 4 wage range according to the FLC Data Center, the prevailing wage website. And then if they didn't receive enough applications in the level 4 category, they would go to level 3. And then if any were left, level 2 and 1, although based on projections, it was considered unlikely that anyone lower than a level 3 wage would be selected. So this was the proposal made by the previous administration as they were on their way out. We were kind of in a waiting mode earlier this year, waiting to see if that would actually be implemented for March 2021's lottery. At that time, I believe in February, the new administration basically put that implementation on hold, saying that it needed to be reviewed, and so it was not a factor in this year's lottery. Recently, the Biden administration has signaled its intent to defend this wage rule, this wage-based lottery rule that was proposed by the previous administration, a lot of employers, chambers of commerce, employees were hoping that the new administration, upon their review, would basically decide not to implement it since it is extremely problematic. There are a lot of issues with it. There is a pending lawsuit that lists out the different problems with the rule. But unfortunately, the Biden administration recently signaled that they are intending to defend the rule in their lawsuit. So there are still a lot of reasons why the rule is still problematic and may not go into effect. For one thing, it's not there's no statutory basis, essentially. And that's one of the arguments in the lawsuit, that the statute that sets up the H-1B lottery system does not include a designation for priority based on salary level. So it's not confirmed that this rule will go into effect next year, so we'll need to watch it pretty closely. If it does go into effect, it is going to have a significant impact on the lottery system. Basically, it's projected that you essentially will need a salary offer in level 4 or 3 in order to have any shot at selection.
Let's say, Rebecca, I'm working in San Jose, or probably I'm working in San Diego, or maybe New York area where the cost of living is very high, and I am at level 1 there. Can I move to Kansas with the same position? And if I fall into level 3 or level 4 there, because same salary, and if I'm going to be working at Kansas, can I file in the Kansas location, Emily, Rebecca?
Theoretically, and that's kind of one of the problems with the rule, that it could, in effect, kind of lead to these inconsistencies for, because the FLC data center and the prevailing wages are based not only on SOC code, but geographic area where the work site is expected to be. If you're in the same position, basically doing entry-level work, your prevailing wage in somewhere like New York or San Jose is going to be much higher than somewhere like the Midwest, just by virtue of the way the prevailing wages are determined. And so it could theoretically lead to a situation where if you just relocate to another area where your work site does not have as high a prevailing wage, your work is essentially the same, but all of a sudden you have a level 3 or 4 prevailing wage and could have more priority in this wage-based system. So that's another reason why it's not really a good rationale for this system.
What about, Rebecca, if I were to file a H-1B, let's say with Reddy Neumann PC, at a level 4 salary, and you pay me in the month of October, in the month of November you file an amendment for level 1. Is any of the regulations prohibiting that at this point of time?
Technically not. Yeah, so that's another reason why the rule is really not a good idea. There's nothing preventing a petitioner in March from saying that the salary is this amount, and then maybe actually paying the H-1B beneficiary at that rate for a very short time period, but then filing an amendment to change it to something else. This sort of system really is an invitation for a lot of fraud in the H-1B lottery system.
Good news, guys. Now you guys are not going to be called as aliens, especially in the immigration courts, though. In the immigration USCIS, you may be still called as alien, and there's still an alien number. Hopefully, so the USCIS also adopts the same rule what the judges has put, because I personally don't like to call myself an alien because I came in as an alien. I had an alien number that still is allocated to me. So it's kind of significant for me and the people. I understand they don't like to be called aliens. Foreign national is good, applicant is good, petitioner is good, beneficiary is good. Definitely alien, I don't like it, but that's good news that we got from the court. They're not going to call us aliens anymore. Hopefully so in the near future, USCIS will not call aliens. We'll go to the questions. I want to go to the common questions that are coming out with regards to the priority date expectation. If you guys are within December 31st, 2018, if you're contemplating changing the job, my advice is do not change though. That's my personal advice. I know I'm not going to back it off. I've gone wrong so many times. Believe me, in 2007, when it became current, I went wrong completely. In 2020 October, we did not expect that the prior date will move to 2015. There are records there that says that we only expected until 2012 or 2013. There are 150,000 extra green cards. There's a lot of pressure on the State Department right now, and thank you guys, because we have seen you guys writing thousands and thousands of letters to the congressmen. I've seen people posting a response what they got from the congressman on the Facebook and sending it to me. Instead of sending it to me, I really like you to post it on the Facebook and tag me if you want to on the Facebook. I really appreciate that, rather than sending an email, because nothing I can do for it. So if any of you guys are still not writing letters because they're going to waste 260,000 green cards, almost all of them would have gone to the countries who have been oversubscribed, which is mostly India and to some extent Chinese nationals. So I really recommend all of you guys to write it, have your friends write letters. The draft of it is there at the bottom. If you go into in see more, you can see it. For those people who are accessing this in the mobile media, that is on a smartphone or iPad, you may not be able to see that, but if it's in a computer, desktop or a laptop, you'll be able to see that, and you can draft the letter, pass it on to a lot of friends, so that we don't have to waste these green cards. If we waste these green cards, it may take 26 years for us to get these green cards. Question that is coming out with regards to Aztec. It's been a long time that I hear that name. This is from Neeraj Rathod from YouTube. He got an RFE from because he was an OPT with employment with AZ Technologies LLC. I want to describe to the people that this company called AZ Tech, along with two other companies, also called as Integra Solutions, and also called as Wireclass. What's the other company? I forgot it. And these people took the money from a company called Wireclass. They took the money. These people provided the employer letters, though. What happened was that when the ICE published the employers in the OPT and STEM extension, Integra came out number 2 employer, next only to Amazon. But if you count Integra, Aztec, and Wireclass, they are actually number 1 employer over Amazon. So there was an investigation done on these things. They found out that the employees have paid anywhere between $250 to about $2,000 to obtain the employment letter, and some of these people have also signed the 983 application, though. None of these people have visited this company. None of these people have ever met the employer and any employee of Aztec, Integra, or Wireclass. And what happened is that these 3 companies were having one address in Delaware, seems to be in a shopping complex next to a barber shop, or probably in a barber shop itself. Looks to be, when I investigated into that, that's all I found out. So when we collected all the dots, it were approximately 4,700 people took the employment letters, and the USCIS and ICE and CBP is going against these people. Some of them were being detained, some of them were being sent back when they were trying to come into this country. Some of their visas were denied. Some of their change of status were being denied also, and they were being sent to notice of intent to revoke for some of the H-1Bs. So definitely, if you fall into any of these companies' criterias, you should contact a lawyer. And this is another note that I tell people not to fall into this trap of employers who will tell you that they are going to do things that are not legal. They may tell it's legal. You need to be very careful that a lot of people who have been victimized by these companies contacted me. They said, I didn't know the law that I shouldn't pay for the employer letter. I didn't know that I should be taking the proper training rather than just they sending the PDFs though. The law, the number one rule in the legal principle is not knowing law is not an excuse. There are also people who say that, well, it's the employer has the tax ID number, the employer has the, what is that, for the extending of the STEM extension, the e-verification number. The employer has the e-verification number. We believed it. No, that is not how it works in the United States. Not only in the United States, in almost all common law countries that I know of. I'm an LLM student. I am a lawyer from India. Most of the common law countries is that you have not knowing a law is not an excuse. Even if the president of this country comes and tells you to do, it is your judgment call to evaluate whether or not it is legal or not. Even if the lawyer tells you, even if the president of the country, that's what President Trump told all the people to go into Congress. These people went into the Capitol building. Some of them will be hanged. I mean, some of them will be put to death because of the activities they've done. They will be responsible for it. So be careful on the people who are going to talk to you very sweet. So be careful. It is up to you to evaluate whether it's legal or not, and especially 4,700 people falling victim into it is definitely a sad thing. I definitely, if they are aware of this, if they are aware that they should not be doing it, I bet they would have fallen into trap into these things. We also advise the same thing on day one CPT universities in the similar fashion. Please be watchful on those things. We do not endorse any day one CPT universities for the same reason why these 4,700 students got into trap. We do not endorse day one CPT universities. Rebecca, questions?
Lakshmi is asking, in what order does USCIS process I-485 applications? Is it based on the received date, on the receipt notice, or the notice date, or priority date? So as far as the I-485 processing, we know that one of the essential steps is having your biometrics taken, unless you happen to get a message saying that your biometrics are being reused from a previous collection, which has been happening in some instances. But for most people, their biometrics need to be taken after the I-485 is filed. I would say that for your biometrics appointment to be scheduled is, for the most part, based on received date, on the order in which the I-485 applications are filed with USCIS. From there, in order for your I-485 to actually be approved, there are a few things that have to have happened. Besides your fingerprints being taken, the immigrant petition that it's based on needs to be approved. So that's the I-140 petition in a lot of cases. If your I-140 downgrade, for example, was filed concurrently with the I-485 last year in October, the I-140 needs to be approved before the I-485 can be approved. After that, the priority date needs to be current according to the final action dates chart, Chart A in the visa bulletin, before the I-485 can be approved. So that's where the priority date does factor in, even if your case, the received date is much earlier than someone else's. If your priority date is not current according to the final action dates chart of the visa bulletin, it's going to remain pending until the date becomes current. So if you have those three things, the fingerprints taken, the I-140 approved, and your priority date is current, your I-485 application can be approved at that point. That doesn't necessarily mean it will immediately be approved in the same month that the final action date becomes current. That's the best case scenario, of course. That's what we hope will happen. And in some cases, we have seen that happen. I would say from there, once those three conditions are met, the rate at which the I-485 is actually being approved seems to depend a lot on where the file is, which service center or which USCIS field office. And we know that USCIS seems to be distributing the I-485 files kind of across different service centers, different field offices, hopefully in an effort to speed up the processing and get them processed faster. But it does seem to depend a lot on where the file is. It could be at a local USCIS field office where you do not live, and if they don't have too much backlog, then we've been seeing some of those cases get approved pretty quickly. Sorry, I forgot to mention one more thing. Your medical exams do need to be submitted. So if you did not already submit your medical exams with the initial I-485, you can wait for the RFE to submit it, but we recommend that you can try interfiling it, basically just trying to send it to USCIS, so that cuts out the step of the RFE.
A lot of people are asking, what is the prediction for the priority date? I'm still standing, guys. If you have the priority date before December 31st of 2018, I want you to be prepared. I mean, you don't have to spend tons of money to be prepared. One is get the birth certificate. Make sure you check with your employer if they are willing to downgrade. And if they are willing to downgrade, if I were you, I would have them downgrade right now. That extra money that you spend on the I-140, if I were you, I would do with it. The reason is that if you downgrade doesn't mean that your existing EB2 is gone. You have both. You can travel in any of those things. There are a lot of changes that are popping up right now. COVID is not going that soon. There are a lot of things that are popping up. So I want you, if it is until December 31st of 2018, I definitely don't want you to move from your current company to some other company. And if from previous company has your I-140 approval, I will start negotiating with them at this point of time, asking, hey, are you willing to take back? Are you willing to support me in the 485 application? I would like to start the negotiation right now. Would I get the medicals done? No, I would not get the medicals done, but definitely try to prepare, get the I-140 approved in the EB3 and birth certificate, make everything application ready. If your law firms are offering I-485 application, that means that, hey, why don't you charge a little bit money, but do all the 485 and make it ready? I would definitely do that thing. And if your company allows you to go to the independent lawyers, we are welcome to take you. It's an investment that we are doing into. We don't charge you a lot of money. We charge you a token amount of money, and we prepare your entire 485 application, make it ready, except of course the visa bulletin missing, and if there is anything missing. It's very surprising. Out of 10 cases, there are faulty things that are there. A couple of people have their I-94 was expired. They came on a passport visa that expired, and I-94 expired. Things are wrong in the way that they are expressing themselves in the employment based. Like the person was working until 2018 for a company of India. I said, how can you be working? I was on the leave. You're not supposed to mention that if you're on the leave and if you're in United States, don't mention that you're working for the company. So it's all these things. There are a lot of problems that will be there. It'll be easy to cure at this point of time rather than going all the way to September of 2021. People may criticize. They may say, hey, Charlie didn't said it's going to be 2018. Yeah, Charlie didn't want to do a lot of things. We may have to force him to do it. That's the reason we have these Congress letters that I do expect all the people who are listening to this one, right? It's not, a lot of people will say, well, I'm going to start an online petition. No, I wouldn't advise you that. The letters that Emily has drafted, or other business partner other than Rebecca and me, that is the best one that we suggest. Or if any other lawyer or any of you guys want to write your own personal letters describing what all are going on, please do it. And the letter that we drafted, please personalize it to yourself. Explain your family thing, how long you have been waiting, what are the difficulties that you face. Look, you are coming to this YouTube and TV show. I mean, you shouldn't be here. You should be getting the green card. You should be producing more. Either you should be having a grilling, or you should be in a swimming pool. I don't know. Maybe you should be playing tennis or cricket. The fact that you're here at 5 o'clock Central Time, I don't like it. I mean, you should be more relaxed at this point of time. That is a difficulty too. I mean, traveling every time you go outside the country is a difficulty. Kids are aging out, that is a difficulty. Extending the H1B every time is a difficulty. Extending the H4 is every time is a difficulty. You want to buy a house, that's a difficulty. I mean, think the mental peace that you will have if you have a green card is definitely a thing that you deserve to get it for the hard work that you did it. For the you've been paying taxes. Please mention all these things, whatever is personally applicable. Send it to the congressman. If you have any teenage kids, though, I definitely tell those teenage kids who are not U.S. citizens, of course, they should contact the congressman. They should write their letters. They should represent. And I also listed out a Telegram page in there. If anybody is in a San Jose area, there's a group that is trying to go and meet Zoe Lofgren. She is the best congresswoman that understands the per country limit, has been fighting to take off the per country limit, and she would be the best advocate for us in getting the 260,000 green cards. The links are provided at the bottom. Please use those things.
We have a couple of questions about birth certificates and if the applicant or the witness's full name is not printed on the birth certificate, or if the applicant's name is not listed on the birth certificate exactly the same way as it is in the passport. Those are, for the most part, they are fine. We have another video that we've done on the topic of birth certificates.
It's already, we give a link also.
Yeah, so we would recommend checking that video to get the FAQs on birth certificates. For the most part, name differences will not be an issue.
Names are spelled differently at different languages, especially if you're coming from India. I mean, Anita will be spelled as A-N-I-T-A in North India. In the South India, it's spelled as A-N-I-T-H-A. Sometimes they add Bain for the Bain for the Maharashtra and Gujarat. Sometimes they add Sri, sometimes they add Srimati. There are a lot of things. Those minor corrections does not matter, but we have given a good video. Rebecca and I presented it. Please watch that video if you have any questions on the birth certificate. The people are asking questions about, is there any premium processing for the EAD? Unfortunately, no, not at this point of time. There is no premium processing for EAD.
There was a question about EADs connected to the I-485 applications and if the I-140 needs to be approved in order for the EAD to be issued. So the answer is no. The I-140 and the I-485, even if they are filed concurrently, they're kind of processed on separate tracks. So if your I-140 hasn't been approved, that's not the reason why you don't have the EAD yet. Most likely the EAD is just taking a long time because they take a long time. I would say the majority of the I-485s filed last fall are still awaiting the EAD AP cards. Some of them have definitely gotten approved and issued, but it's not uncommon if your EAD AP have not been approved yet, and it's not waiting on the I-140 to be approved, basically. If your priority date is current, though, or expected to be current soon, it is still a good idea to upgrade your I-140 to premium processing to get it approved, so that that's one less thing that has to be waited on for your I-485 to be eventually approved.
Srini from YouTube has this, he did the 3 activities. From now onwards, we're only requesting 2 activities. The third activity, writing to Visa Bulletin, we're going to update it after our staff meeting tomorrow, after our partners meeting tomorrow. At this point of time, we will request you to write 1 letter to the congressman, and a copy of that to be sent to Joey Lofgren from San Jose area. He's asking the question, can I file I-485 when I-140 downgrade to EB3 is still pending? Absolutely. It doesn't have to be approved. If it's pending, you can still file the 485 application. There's a question that comes from a physical therapist. That is Pradeep Shuri, and I don't like physical therapists that much, guys. No, I'm just making fun of you. My wife is a physical therapist. He has a question that my priority date of EB2 is March 2012. Should I downgrade or wait for the EB2 to come current? Pradeep, I want you to go on the path of applying for EB3 soon though. The reason is that you will have two options, EB3 and EB2. Just for the other people to understand, for physical therapists, it's a little bit different ball game than that of the regular IT professionals. They can't just downgrade it as easy as you guys do. It's a little bit different process. Pradeep already knows that, and that's the reason he specifically pointed out that he's a physical therapist. Yeah, I would go on the path of downgrading so that I will have both options available. I want to get out of this hell as soon as possible. Whichever way, I don't care whether it's a horse, whether it's a camel. I don't care. I will go. I want to buy the 2 tickets. I can afford to buy the 2 tickets. I know you're a physical therapist. I know your salary because I know it's standard almost the whole United States. So my wife is a physical therapist. It's a decent salary you guys make it. And, I passed my bar, and my wife paid me for all those things when she was a physical therapist, and she's still a physical therapist. So yeah, it's worth definitely for you to invest into EB3. I would strongly suggest you do.
Rohit's question is about filing the I-140 and I-485 concurrently. His perm was recently approved. It sounds like his priority date is current. Yeah, definitely we recommend filing the I-140 and I-485 concurrently. There really isn't any reason why you shouldn't, or any downside to filing them concurrently, unless there is some risk factor in the I-140 that you think there's a high chance of denial on the I-140 for some reason. And then even in that case, the worst that would happen to the I-485 application is that it would be denied along with the I-140 denial. It doesn't prevent you from refiling the I-140 and I-485 later if you've had a denial on either one of them. It's mostly just the loss of the filing fees for the I-485 application. But otherwise, if there isn't any high risk of the I-140 being denied, we definitely recommend filing both together.
Rebecca, I want to go on the commonly asked question on the national interest exemption though.
Okay.
So walk me through the process. Let's say, for example, I'm not exempt from the travel ban. I don't have a U.S. citizen children. Mm-hmm. And if I'm going to India for the H-1B stamping, walk me through the process. Can I go through the Dropbox?
So you can submit an application through the Dropbox if you meet the Dropbox requirements for it being a renewal. The previous visa was not expired within the past 48 months, I believe, and you're applying in the same visa class. However, in addition to that, you need to obtain an NIE appointment, and that is separate from the Dropbox. For consulates in India, there is a page on the State Department website that lists out the NIE email address. Basically, each consulate has a specific email address where NIE requests should be directed, and you'll need to go to that website, find the email address for the consulate that you'll be applying at, and send in your national interest exception request and documents to that consulate through that email address, and then wait basically to hear back from the consulate on whether they believe you've made an initial case on your eligibility for the NIE, and
if they give an appointment to me in the initial case, can I assume that my NIE will be approved, Rebecca?
No. So just getting an appointment for the NIE is not an automatic approval. So you do still need to be prepared to make your case for the NIE. If you aren't qualifying based on a family relationship to a U.S. citizen, for example, for the most part, your argument is going to be based on your work, that your work is contributing. It's a part of the critical infrastructure in the U.S. And there is a memo that kind of outlines the various areas identified by DHS as critical infrastructure or contributing to critical infrastructure. So that does include information technology professions that support areas of critical infrastructure. So we do recommend that you have a pretty detailed letter from your employer spelling out exactly what your work is and how it supports an area of critical infrastructure. If the employer is willing to provide things like project documents, statements of work that show that you are assigned to a specific project that is in that national interest area and that there is an imminent start date or kind of a project timeline that requires your presence in the U.S. Pretty urgently, that is very helpful. We always try to include work orders or any other project documents in the NIEs that we draft for our clients. So that's a letter from your employer, signed by your employer, and any other supporting documents related to that.
How long normally the consulates in India are taking to give a response to that?
I think it varies. I have had clients who receive a response sometimes within a few weeks from the consulate, but it does seem to vary from consulate to consulate.
And what are the, can I get this NIV waiver before I even go there? Because I don't want to take a chance there and see what my luck would be.
I don't think you can apply for the NIE like while you're physically in the U.S.
Yeah.
No, I don't think you can, because you do need to include in the NIE request kind of your travel plans back to the U.S. Like if you have travel already booked to the U.S., they want you to include the details of your flight so that they can also sort of prioritize appointments based on that.
People are asking questions about the H4 Ead lawsuits. Since we filed a class action suit right now, we are not taking the H4 Ead lawsuits, guys. The class action lawsuit is still there. We're expecting some positive result right now. So since the class action lawsuit is already there and we are also part of it, we are not filing the H4 Ead litigation. And the H4 Ead litigations that were filed in 2021 were not as successful as they were in 2020. That's another reason why we have stopped filing H4 Ead delay lawsuits with the USCIS.
There's a question about upgrading the I-140 to premium processing for someone whose party date is kind of in mid-2014, and whether it's still recommended in that case when the party date is still quite a ways away. It's up to you. I would say that it doesn't hurt to upgrade to premium processing and to just get it approved so that that's locked in. There are other benefits to having the I-140 approved, even if the I-485 will continue to be pending for a while because of the priority date movement. Basically, once your I-140 is approved, it gives you more flexibility to change employers if you want to and are eligible based on AC-21. For the most part, if you filed your I-485 application last fall, you are eligible for AC-21 since it just requires your I-485 to have been pending for 180 days or more. However, it's recommended that you don't change employers even if you're able to, even if you're past that 180-day mark, until your I-140 is approved, because if your I-140 petitioner ends up withdrawing the petition after you leave, it could make it more difficult to proceed with the application. You basically will have to prove to USCIS that that I-140 petition was approvable, which could be difficult to do. So it may be a good idea to upgrade to premium also to give yourself more flexibility in that sense.
Questions on the advance parole. Can I travel to India and come back? Do I need to apply for NIE? Yeah, you have to apply for NIE to come back if you don't have any US citizen children though. The only exception that's there is that you can definitely go to India and spend 14 days in Mexico or in Sri Lanka, and then you can come here. I mean, you don't need that letter because by the time you are even being granted that one, it's taking about 4 to 8 weeks. So it may not be worth for you to wait that long. You may actually go to Mexico or to Sri Lanka to get that exemption to come into. I mean, since you're waived, you already have the visa. You can come into visa. I mean, advance parole. You can come into the United States without problem if you are willing to spend that extra 14 days.
We have a question about upgrading the I-140 to premium again, and sorry, I lost the question now, but I believe it was about
in
the
general,
timing.
though, what we suggest is that unless you have a teenage kid, though, for everybody, I mean, unless there is some exception there, unless you have a teenage kid, everybody who has an I-140 pending, though, we suggest people doing premium processing. We know the cost involved in it. It's $2,500, and your lawyer might charge some amount of money. They don't charge significant amount of money for doing premium processing. We strongly suggest that you should do premium processing. Is it worth? Believe me, it is worth. I have been an immigrant. My wife's I-140 was been pending for a long period of time. In those days, we couldn't file the 485 when the I-140 was pending. That was a law in those days, even though the priority date was current. Yeah, so that's the reason why premium processing, even if your priority date is not current, you can't file the application. There are multiple benefits that you get it if you get the premium processing approved. There are a lot of people who go all the way down and find out that they lost the job. They should have done the premium processing before. They didn't. It's really damaging. And another reason is that it's a peace of mind. I mean, you don't want to be stuck with an I-140 that's pending there. It's always good to get over it, and then you're fine after that. That will be much better for you to go. A question that came out with the birth certificate is that, does the dependent also has to submit the birth certificate? The answer is yes. But if they don't have a birth certificate, then there is a link there, and the title of the link is actually, I don't have a birth certificate. What do I do? So that link is there, and you can follow the link at the bottom for you to review that.
Vijay is asking, when applying for the I-485, do you need to have a minimum of 6 months of H-1B validity? So no, you don't. You don't need to have 6 months in advance of any NIV validity in order to file the I-485 application. You just need to be maintaining a valid non-immigrant status at the time your I-485 application is filed. Actually, there are some rare instances where if you are inadvertently out of status, it may be possible to file the I-485, but you should consult closely with an attorney before filing that to make sure that you're still eligible. And we have had some situations, we do get some questions of your I-94 was expired, but you filed a timely extension, and the application for the extension is still pending. At that time, can you file the I-485 application? And the answer is yes. You're technically in a period of authorized stay, and this is most often in the case where the H4 applicant filed their extension. Their I-94 has already expired, but the I-539 application is still pending because it's just taking so long for I-539s. You can still file the I-485 application when you're in that situation. Just make sure to attach a copy of the I-539 receipt notice to show that you applied for the extension timely, and then you just need to make sure the I-539 eventually gets approved. If it is eventually approved, then there's no problem.
A question from Avinash is that, what are your expectations for the final action dates for the October visa bulletin? Our final action dates, we are not expecting much movement in there based on the Charlie's comment. But of course, he can still change the mind, especially with all of you guys writing letters to the congressmen, the congressmen putting a pressure on the state and the USCIS. Definitely, it may have an impact, but we are not expecting. It's the filing dates that we may see a drastic movement in October of 2021. When people are asking questions, Chandu is asking the question, if the perm is filed today and his max out date of 6 years is expiring in August 2022, is he expected to get the I-140 approval by the time? Right now, the perm is taking about 6 months to get adjudicated. But please note that before the perm is filed, though, there is a process for the perm labor, though. That process itself, depending on how you do it, it may vary between 5 months to 8 months. It's not like H1B. I mean, you come to us, we file an LCA within 5 to 6 days. We could file your H1B in 6 to 7 days at the max. But when it comes to the perm labor, though, the minimum would be 5 months, and at about 8 months is where the average normally will be, depending on how the employer will file the labor certification, how he does advertisements, and certain other aspects that need to be taken care of. So for those people who are intending to stay in this country on H1B for a long period of time, though, don't start the process when you enter the 4th year or 5th year. Try it in the first 2 years. And that's another reason why Rebecca was pointing out getting an I-140 approval in premium processing also will be helpful, because if you want to change the company, you can change after 6 months. Even if the company if withdraws, it won't have any negative impact.
We have a question from someone who is currently single and their priority date may be current soon. If they file their adjustment of status application, they want to know how their future spouse, when they do get married, can be added into the application. So you do have to kind of plan this and time it pretty carefully. Basically, the rule is that if your I-485, anytime while your I-485 application is still pending, if your spouse is here in the U.S. in a valid status, they can file the I-485 application as your derivative, file it separately when your priority date is current. So as long as your priority date is still current according to the final action dates chart, they can file their I-485 at any time when they are here in presumably H4 status, or if it's current according to the filing dates chart and USCIS is allowing using the filing dates chart, they can file it. What becomes complicated is basically that ability to add in your spouse, to have their I-485 application filed as your derivative. That basically ends once you receive the green card, once your I-485 is approved. If your spouse has not filed the I-485 at that time, it becomes much more difficult. They basically then need to go through the family-based process to apply as the spouse of a green card holder, which can be very complicated because, of course, if they are here on H4, their H4 status ends on the day that you get your green card. So there is a lot of timing involved. You do have to get that I-485 filed by your family member as soon as possible when your priority date becomes current, but before your I-485 gets approved. Because of that, you also want to make sure you are maintaining your H-1B status so that they can apply for an H-4 visa stamp and get here to the U.S. to be able to file that adjustment of status.
Question, is there any way we can litigate off the USCIS or State Department not wasting 100,000 green cards? We are definitely considering it. We will update you in the next 1 to 2 weeks about that activity. There are some, our initial discussions with our litigation lawyers in our office and the partners that we have in Washington, D.C. Is not doing good on that, and we're still trying to see if there is any other way to do it, but we'll keep updating you as you come in. Also, for the people who, there is a daily conference call, guys, that I or Rebecca will be there. Any one of us will be there, half an hour it will be there. The link is provided at the bottom where you can go and find out the timings. It's normally at 11:30 and 3:30, and on Wednesday it's at 4:30 Central Time. So you can find those daily conference call. You can ask the questions there too. If you feel that you're not getting the attention here, you can ask the question there too. And we would like your feedback, guys, on how we can improve on. What can we do better in our presentations? We would like you to have your feedback so that we can improve better, so that we can serve you much better than what we are doing right now.
Ramesh has a question about H-1B visa stamping. He's on an L2 visa right now and wants to know if he can apply for the H-1B visa stamp for the first time in a consulate in Mexico, for example, rather than in India, in his home country. So yes, that is possible, although you should be aware that there are also significant scheduling backlogs in consulates in Mexico and Canada. similar to consulates kind of worldwide right now. Appointment availability is usually several weeks or months out. So I would recommend looking at the consulates in Mexico at their schedule availability first before making any travel plans. Hopefully your L2 EAD is still valid for a while to give you a bit more time to plan out that H-1B visa stamping trip.
Win-win from YouTube has this question. His wife is in India on advanced parole. Can she travel to USA staying 2 weeks in Mexico? Yes, she can. I've been informed that there are a lot of travel agencies that are giving surveys where, if you're interested in eating Indian food and all those things, they have these hotels reserved just for Indian travelers only, that where you can go to Mexico and you can be there for a while and you can come back. That's provision is there for you guys to do it if you want to avail that. Any other questions, Rebecca, before we close?
Not right now.
Well, thank you guys for tuning in. If you have any feedback to us, we really appreciate you giving a feedback to us. That will really guide us in a better fashion. This YouTube and the daily conference calls, we get educated from you too. It's not all the time that we are just telling you. There are a lot of information that you provide that becomes very helpful as a lawyer. It's important to know what's going on with you guys, and just by doing the cases, we don't get as much as education as much as the feedback that you give it, the information, the questions that you ask gives us a knowledge what you're thinking, what is your importance, what exactly is going on in your mind. It's a very good exposure. We really like your feedback. We really like you coming in, tuning into YouTube and this Facebook. Thank you very much. Anything else, Rebecca?
That's all. Thank you.
Thank you very much.